There are a lot of things that can happen if you don't plan properly for the future. Namely, in the elder law world, we worry about unnecessary litigation. For example, a guardianship proceeding if a power of attorney isn't properly drafted and executed, or the need for the court to intervene in financial decision-making if documents are not properly in place. There are many downsides to guardianship proceedings, not the least of which is their cost and the length of time it takes to litigate even uncontested proceedings. Most often litigated in the guardianship realm is either who will be the appropriate guardian or what powers that guardian should have, namely whether they should be in charge of finances or medical decisions or both. When a court is making a determination about the appropriate guardian, they will often look to the experience of each person proposing themselves, the ongoing relationship that person has with the incapacitated party, and what their plans are for the incapacitated party in the future. After the appointment of a guardian, the work actually just begins. Guardianship is a long-term relationship with the court, including annual court oversight and review, and it can be a very burdensome process. The legal standard to appoint a guardian is the highest burden we have in civil cases, and meeting that burden can be somewhat difficult and would involve documents and interviews. It's a long process. If a court determines a guardianship proceeding should not have been brought, the petitioner risks having to bear all of the legal costs of all of the parties who are involved in that proceeding, and that can be quite costly. In order to ensure that a guardianship application will be successfully heard, we do a very thorough interview with our clients, a review of any documents that are already in place, and we have a very long-term relationship with the clients to understand what their goals are and whether those goals can adequately be met through a guardianship proceeding. Mental health challenges in the guardianship realm are a particular niche area that we've been working more recently on. There are many differences in the way these cases are handled. Primarily, how can we get services for the person who's suffering from the mental health impairment through the guardianship realm, and we do face challenges with what's available to provide for such a person through the Article 81 proceeding. We had a case recently where we represented the family members of an incapacitated person, and in challenging that person's accountant as the guardian. And through a long-term hearing process, we prevailed in making sure that the family members were the people who were the guardian rather than some professional who had a remote relationship with the incapacitated party. I'm motivated to come to work every day because I believe that this is a really important area of the law. I don't believe it's very well understood by many lawyers in practice. I believe it's an area that needs a lot of strong advocates to make sure that the rights of those who can't speak for themselves are protected.